Welcome to this presentation on legal issues in healthcare. In this session, you'll learn about sexual harassment in the workplace. Then you'll be introduced to tort and learn the various types of tort seen in healthcare. You will learn some legal terminology and learn about several legal issues that you may encounter during the course of your work. And finally, you'll learn about ways of avoiding legal issues as you perform your duties in the healthcare setting. Here's a list of the topics we'll be covering and the slides on which you'll find them. We begin with slide 4, sexual harassment. On slide 5, we define tort, and on slides 6 to 7, we talk about the various types of tort in healthcare. On slides 8 and 9, we define legal terminology that's important to healthcare. And on slide 10, we talk about several ways of avoiding legal issues in healthcare. This is a very intriguing topic. Let's take a peek into the legal world of healthcare. In the everyday work of healthcare providers, there are many activities that, if performed without care or skill, could result in a lawsuit. And persons performing phlebotomy can be held legally responsible for their actions. It is therefore important to be familiar with legal terminology. The next few slides are going to go over these terms. Sexual harassment is a form of sexual discrimination and violates the Canadian Human Rights Act. It is defined as persistent or offensive conduct related to a person's sex that negatively affects a reasonable person's job. Essentially, it is non-consensual or unwanted sexual behavior, usually intended to exercise a form of power over the person being harassed. It's different than workplace harassment, called hostile work environment. Let's delve into some very interesting legal issues regarding healthcare, mainly for the purpose of avoiding them. Tort is defined as a wrongful act against a person, property, or reputation, committed without just cause, intentional or not. It includes assault, fraud, invasion of privacy and breach of confidentiality, malpractice and negligence, respondeat superior, standard of care, and vicarious liability. We'll touch on each of these in the next few slides. There are various types of tort we may encounter in a healthcare workplace. Assault is an intentional threat or movement that could make a person feel in fear of immediate harm. Note that this does not need to involve actual physical contact. Fraud is wrongful or criminal deception intended to result in financial or personal gain. Invasion of privacy is a violation of one's right to be left alone, such as telling others that a patient is in the hospital when that person doesn't want others to know. Breach of confidentiality is the unauthorized release of medical information concerning a patient. Confidentiality in healthcare is paramount, and there are legal rights protecting it through the Personal Information Protection and Electronic Documents Act, or PIPEDA. Breaches to this are taken very seriously. Unauthorized release of medical information includes during the course of your work, even among coworkers. A simple question you can ask yourself is discussing this patient's private information necessary for me to do my work? If the answer is no, then you should not be discussing the patient's information with anyone, even coworkers. If the answer is yes, it should be a private conversation. This includes printed or posted information about a patient's health information, even if it's posted in the lab. PIPEDA requires that printed documents with patient information are flipped over when you're not working on them. However, it is okay to share information among coworkers about where to find a patient's veins if they're difficult to find. If it is necessary to do your work and it does not involve releasing private medical information, then it is okay. Continuing with types of tort, malpractice is a claim of improper treatment brought against a professional. It implies that the professional is trained in that area of treatment and that a greater standard of care was expected. Negligence is failure to exercise due care or to provide a level of care that a reasonable person would give, resulting in an injury. For example, failing to put a needle in the sharps container, failing to replace a patient's bed rails to the upright position after lowering them to collect blood, or failing to ask a nurse to restart an IV after turning it off to collect blood. These are all things that a reasonable person would have done, whether or not he or she is specifically trained to do it. Respondeat superior is a Latin phrase meaning let the master respond. It means the healthcare institution is liable for our mistakes. We are responsible, but the institution is liable. Standard of care is a set of standards set by licensing and regulatory agencies. And finally, vicarious liability is institutional liability for injury resulting from negligent acts committed by independent workers hired by the institution under contract. So the hospital is not free of liability if a patient dies from a hospital-acquired infection, even if the hospital contracted an outside company to do the cleaning or hired an independent MLA to draw the blood. Next, we'll touch on legal terminology, because there are a few legal definitions of which you should be aware. Risk management is an internal process focused on identifying and minimizing situations that pose a risk to the patients and to employees. Confidentiality is the ethical cornerstone of professional behavior. It is a practice of protecting patients' rights. No private information about the patient may be released. We know we must get consent before performing a venipuncture. Let's discuss the various forms of consent. Implied consent is indicated by the patient's actions. It's a form of nonverbal communication. For instance, if you enter a phlebotomy room and tell the patient you're there to draw a blood sample, and they begin rolling up their sleeve and extending their arm towards you, their actions imply that they understand and willingly consent to the procedure, even if they don't say it verbally. Informed consent means that the patient is fully aware of what he or she is consenting to, along with the risks involved. For instance, if you enter the room and tell the patient you're there to draw blood, and they don't seem to understand, perhaps they've never had blood drawn before, you inform the patient about the procedure, like, this involves inserting a needle into your arm to collect some blood for tests that the doctor's ordered. It may pinch a bit, but it should only take a few minutes. If the patient agrees, this is informed consent. Express consent is verbal or written permission, usually only used for high-risk procedures like surgery, not for venipuncture. More legal definitions include discovery, which is a formal process in litigation that involves taking depositions and interrogating all parties involved. A deposition is a process in which one party questions another under oath, while a court reporter records every word. A plaintiff is the injured party or the person that is suing, and the defendant refers to the person against whom the complaint was filed. So now that you know all the scary details about legal issues in healthcare, let's talk about some measures you can take to avoid getting embroiled in legal matters. First is always get consent before collecting specimens, whether implied by the patient's actions or you need to inform the patient about the procedure. Always respect a patient's right to confidentiality. Never release or discuss any medical information about a patient, even with coworkers, unless it is necessary to do your job. Always strictly adhere to the established procedures and practices. These have been developed over time after continuous review of problems and refining the procedures to make them safer. Always use proper safety containers and devices, like needle safety devices and sharps containers and personal protective equipment, or PPE. Listen and respond appropriately to a patient's request. For instance, if a patient says they have shooting pain when the needle is inserted, Abort the procedure immediately. Always accurately and legibly record all patient info. Document incidents or occurrences using the incident report form to identify the problem, state the consequences, and describe what you did to correct the problem. Participate in continuing education to maintain proficiency and stay up to date on current practices as they continually improve. Always ensure you're providing proper standard of care as outlined in the lab procedures. And never perform procedures you're not trained to do. If you're asked to perform a task for which you have no training, inform your supervisor so you can get the training required. Please take some time to review the following concept questions. Question 1. Two phlebotomists are discussing a patient's condition in the hospital cafeteria. They're overheard by the patient's husband. This is an example of A. Failure to exercise reasonable care. B. Improper or unskilled care. C. Breach of confidentiality. Or D. Mistreatment of a patient. Question 2. Which of the following would not violate a patient's right to confidentiality? A. Posting a Hep A positive patient warning notification on the door of a patient's room. B. Posting a list of HIV positive patients in the lab processing area. C. Sharing vein collection site information about a patient who has difficult veins. Or D. Sharing a mutual friend's pregnancy test results with only one coworker. Question 3. If a phlebotomist blank, he or she is negligent. A. Fails to obtain a sample from a combative patient. B. Fails to return a patient's bed rails to the upright position and the patient falls. C. Reports obvious changes in the patient's condition. Or D. Wears additional PPE even if it's not required for the patient's condition. Question 4. Informed consent means that A. A patient's medical records are available for their review by all healthcare workers. B. All consequences of a medical procedure have been given to the patient. C. The patient received a book outlining all procedures and their consequences. Or D. The patient's confidentiality has been breached during the assessment process. And the answers are: Question 1. Two phlebotomists are discussing a patient's condition in the hospital cafeteria. They are overheard by the patient's husband. This is an example of, the answer is C, breach of confidentiality, which is failing to keep privileged medical information private. Question 2. Which of the following would not violate a patient's right to confidentiality? The answer is C, sharing vein collection site information about a patient who has difficult veins. It is okay to share information among coworkers about where to find a patient's veins that are difficult to find. It is necessary to do your work and does not involve releasing private medical information. Question 3. If a phlebotomist blank, he or she is negligent. The answer is B, fails to return a patient's bed rails to the upright position and the patient falls. In A, you should not obtain samples from a patient who is resisting. In C, you should be reporting changes in the patient's condition to the nurses. For instance, if you drew a patient sample in the morning and the patient was conscious, and 2 hours later the patient was unconscious and you couldn't awaken him or her after several attempts, you should inform the nurse. And D, it is unnecessary to wear additional PPE, but not negligent. In question 4, informed consent means that the answer is B, all consequences of a medical procedure have been given to the patient. It means that you have informed the patient what to expect if they didn't seem to understand the procedure. Concept check continued. Match the terms on the left with the definitions on the right. 1. Assault. 2. Breach of confidentiality. 3. Implied consent. 4. Informed consent. And the options are A. Agreement to a medical procedure after receiving information about the risks. B. Permission for a procedure is indicated by a patient's actions. C. Intentional threat or movement that could make a person fear harm. D. Unauthorized release of information concerning a patient. And the answers are question 1, assault. The answer is C, intentional threat or movement that could make a person fear harm. It does not need to involve physical contact, just a threat of harm. Question 2, breach of confidentiality. The answer is D, unauthorized release of information concerning a patient. Usually this means medical information. Question 3, implied consent. The answer is B, permission for a procedure is indicated by a patient's actions. The patient implies their consent by rolling up his or her sleeve. And 4, informed consent. The answer is A, agreement to a medical procedure after receiving information about the risks or after being informed about the risks. Let's review some legal issues in the lab and how to avoid them. Assault is intentional threat or movement that makes a person feel in danger. Breach of confidentiality is unauthorized release of a patient's medical information. Fraud is wrongful or criminal deception intended to result in financial or personal gain. Invasion of privacy is the violation of one's right to be left alone. Malpractice is a claim of improper treatment by a trained professional, meaning greater care was expected. Negligence is failure to exercise due care that a reasonable person would, resulting in injury. Respondeat superior means let the master respond. We are responsible, the institution is liable. Standard of care is a set of standards set by licensing and regulatory agencies. And vicarious liability is institutional liability for injury from negligent acts by contracted workers hired by the institution. Some thoughts about avoiding legal issues in the lab. 1, get consent. 2, respect patient confidentiality. 3, strictly follow procedures. 4, use proper safety. 5, respond to patients' requests. 6, accurately and legibly record all patient info. 7, document all incidents. 8, participate in continuing education. 9, perform at the prevailing standard of care. And 10, never perform procedures you're not trained to do. This should make you feel better informed about the legal risks associated with being an MLA and provide you with strategies to avoid being embroiled in legal issues. Thank you. That brings us to the end of this presentation.